everybody, Dana Sparks, broker of Maximum One Greater Atlanta Realtors, and today's contract tip has to do with handling earnest money. So I am going to point out a couple of issues or license law issues regarding handling earnest money, what it says in the Georgia Association of Realtors contracts, and then I am going to finish up with some points of practice for you as a real estate agent on how to handle earnest money, how to have that discussion with your buyers, and just how to make sure that earnest money is handled properly, to be in compliance with license law, to be in compliance with the contract, and to avoid any issues with your buyers or have any delays in closing. So stay tuned to the end for some points of practice that will hopefully be helpful to you. So, handling earnest money. So earnest money is money that is also referred to as escrow funds or trust money. It is money that is held by a third party in trust. It's somebody else's money, so it's held in trust, meaning the holder is entrusted to do the right thing with the money and cannot disperse those funds until something else happens. Hopefully that something else that happens is a closing, and it gets credited towards the buyer at closing. But should the contract fail to close, generally speaking, either the buyer or the seller is entitled to that money. So it is important on both sides of a purchase and sale agreement. Both the buyer wants their own money back, and the seller might have a claim to that money. If the buyer were to default on the contract, then the buyer has a claim to that money as liquidated damages for the default on the Georgia Association of Realtors contract and on the RE forms contract. That is laid out as the remedy for buyer's default. But before we ever get to that, the issue is you as a real estate agent, when you are specifically working with a buyer and they find a house that they want to write an offer on, you have to have that discussion with earnest money. And generally speaking, the way the conversation goes is, don't worry, your earnest money is safe based on whatever contingencies we negotiate with the seller, whether that be a due diligence contingency, a financing contingency, an appraisal contingency, contingent upon your current home selling and closing, or leasing out, so forth and so on. So generally speaking, you provide the buyer with assurance that their earnest money is safe. There should be no delays, and it will make a seller comfortable that you are in earnest, have good faith that you will proceed with this purchase and sale agreement to purchase this home. On the seller side of it, you say, look, we're going to take earnest money because the buyer is showing that they are in good faith and they do have every intention of closing on this house. However, should the buyer default, you will get those earnest money funds. You will get that earnest money as liquidated damages for your time off the market based on what it says here in the Georgia Association of Realtors contracts or the RE forms contracts. Just a note, agents, if your buyers and sellers are a party to another contract, you need to check out the contract to see what the remedy for buyer default is on the contract or based on law. What I'm talking about are just contractual provisions in the Georgia Association of Realtors contract and the RE forms contract. So you need to check out the contract provisions for default and what happens to the earnest money in that situation. But so that's kind of how the conversation goes. However, there are a lot of things that happen in between there. We have to deal with the holder. So first of all, let me show you what license law in Georgia states. So in Georgia, license law under the GREC Rule 520-1-.083C under handling escrow funds states that a broker shall not disperse trust funds until they have reasonable assurance that the bank has credited the funds to the broker's account. In other words, you need good funds in the account. And, well, I'll get to the and in a minute. The Georgia Association of Realtors contract in 2022, the purchase and sale agreement, under paragraph B6, where it talks about the holder of earnest money, It also states that the earnest money shall be paid to the holder in a method of payment acceptable to the holder. And the holder has the right to charge the buyer for any cost associated with receiving of the earnest money. Such charges shall be collected separately from the payment of the earnest money. Earlier in the purchase and sale agreement, under the section of the holder of the earnest money, under paragraph A7 under earnest money, the buyer will, paragraph 6 is where the buyer and seller identify the holder of the earnest money. Just a note, brokers are held to license law. A closing attorney, unless they hold a real estate license, is not held to license law. That's a note. I've done separate videos on the discussion to have with buyers and sellers regarding a closing attorney as the holder of the earnest money rather than a broker. But we're just talking about the actual handling of it right now. So further on in paragraph A7 in the GAR purchase and sale agreement, it states the buyer and seller negotiate that the earnest money shall be paid by, and there's options that they negotiate: check, ACH, cash, or wire transfer funds. So the reason I told you what license law says and what the GAR contract further says in the contract is, regardless of what form of the funds the buyer and the seller agree to, the holder, number one, has to agree, and number two, doesn't have to act on those funds until they're assured that they are in the bank. So let's say that the buyer and the seller agree that the earnest money will be in the form of a check. Well, they send a check to the holder, and the holder says, no, I'm not going to accept a personal check for that amount of money. Or I'm not going to accept a certified check for that amount of money. Or no, y'all may have agreed on ACH, but I don't accept ACH. Or yep, y'all may have agreed on a wire. I accept a wire. However, there is a fee for me associated with accepting a wire. So I'm also going to charge the buyer an additional fee on top of the earnest money to accept a wire. The reason I am telling you all of this is because it is incumbent upon you as the real estate agent to understand all of these things and to research all of this information before you negotiate on behalf of your client regarding earnest money, whom the holder is going to be, what the form is going to be, and how it is going to be handled. So there are a couple of things you need to know. Number one, you need to check, I'm not going to number them because I'm going to lose count, but you need to check with the policies of the holder of the earnest money. So what do I mean by that? Well, if the policy of the holder states, number one, if it's a personal check, I am not going to act on that for 10 banking days. So that is in compliance with license law incumbent upon a broker who has a real estate license, but it is also that policy of the holder which they are allowed to have in order to have good funds in the account. So if the earnest money, a lot of brokers and closing attorneys will not take a personal check for over $5,000. Likewise, a lot of brokers and closing attorneys will not accept even a certified check for over $10,000. That has to do with the Homeland Security Act and a tax form that must be filed with the IRS with all sorts of identification information of the buyer that must be filled out if it's over $10,000, unless those funds are received in the form of a wire. And then as holder, we do not have to fill out that IRS tax form. So, and ACH, a lot of closing attorneys and brokers in Metro Atlanta do not accept ACH. So you need to check with the policies of the holder regarding their handling of earnest money, the form of it, and when they are going to act on it. Another point of practice is you as an agent do not commingle your funds. That is also a license law violation for you as the agent to commingle funds. And that is in our Georgia license law. It is unfair trade practice, OCGA 434025B4, which states commingling the money or other property of the licensee's principals with the licensee's own. So that is a license law violation. And what does that mean? That means that if the buyer states, well, gosh, all I have is cash. You say, no problem, give me the cash and I'll write a check for the earnest money. Or the buyer says, I don't have a bank account. And you say, no problem, give me the cash and I'll write a check off of my bank account. Or the buyer states, hey, let me do this. Let me send you the money via electronic means like Cash App or PayPal. And you say, no problem, I'll take your Cash App and your PayPal, and then I'll turn around and I'll go get a bank check. No, that is commingling funds. License law violation. Please, you cannot do that. Another point of practice is, regardless of the side of the, well, let me back up to the form. I highly encourage that you use either certified funds or a wire for earnest money. They are quicker to act upon and they are more secure. Nothing is ever 100% secure, but they are more secure and easier for a broker to act on quicker. So if it's a personal check, let's say it's a personal check and the broker has a policy that I am not going to disperse funds from that check for 10 banking days. Well, if you have a quick closing, number one, you can't use the earnest money for the closing. Number two, let's say the broker has a policy that states if I receive earnest money in the form of a personal check, I'm going to hold those funds for 10 banking days before I'm going to act on them. Let's say your buyer goes under contract and has a 10-day due diligence period, writes a personal check for the earnest money. Let's say on day 3 from the binding agreement date, they terminate, and they terminate before the expiration of their due diligence period. You send a TNR, the seller signs the TNR, just, allowing the buyer, you send a TNR, two scenarios. The seller signs the TNR, allowing the buyer back their earnest money, and the buyer the next day goes and finds another house that they want to write an offer on, and of course that seller is also going to want earnest money. Well, if the broker has a policy, if the holder of the earnest money has a policy that they're not going to act on those funds for 10 banking days, and you are 3 calendar days after binding agreement, you cannot use that money, you cannot use that earnest money on deposit with the broker for contract number 2, because the broker has a policy that they cannot apply it. There's no assurance of good funds yet. So that's another reason. The other thing is, let's say, same thing, scenario, 10-day due diligence period, buyer terminates on day 3, send over a TNR. Let's say the seller, for whatever reason, won't sign the termination and release agreement. Buyer goes out, buys another house, and wants to write that seller's going to want earnest money. You can't use those earnest money funds on deposit with the broker because there is not an agreement in writing between the buyer and the seller agreeing to release those funds back to the buyer. Additionally, this is also outlined, guess where? Yes, in license law. Under GREC rule, under the section of handling escrow funds, GREC rule 520-1-.083b, number 4, it states that the broker may not disperse earnest money until they have received written agreement signed by all parties having an interest in the funds. The parties having an interest in the funds in this situation would be the buyer and the seller. The broker must receive written agreement signed by buyer and seller, and that written agreement must be separate from the contract that directed the broker to hold those funds. You're thinking, okay, Dana, what does all that mean? The contract that directs the broker to hold the funds is the purchase and sale agreement. And even though the buyer and the seller have agreed to contingencies, in my example, a 10-day due diligence time frame, that the buyer may terminate for any or no reason by sending notice of that termination before the expiration of that, and they will get their earnest money back. That's all outlined in the purchase and sale agreement. However, if there is not a document separate from the contract where the buyer and the seller agree to disperse the earnest money back to the buyer, i.e. a termination and release agreement, the release portion of the termination agreement, I still cannot just simply disperse the funds to the buyer. One of the things I would have to do would be the 10-day letter where I interpret the contract, send my notice how I'm going to disperse the funds. Now, I use the contract as my what I'm going to reasonably interpret would be the time frames and get evidence of that, so forth and so on. But in that situation, I do all my research, I write the letter. I cannot disperse those funds for at least 10 days from the date of that notice. Same thing, your buyer wants to buy a house, another house, write an offer on another house. Seller number 2 is also going to want earnest money. You're going to have to go to your buyer and say, hate to tell you this, buyer, but I need another check for thousands and thousands of dollars. And the buyer's going to say to you, the agent, wait a minute, I just gave you a check for thousands of dollars that you told me was completely safe based on the contingencies in the contract. And you're like, well, it is, but we have a slight delay. And you're going to get it back, but you're going to get it back in 10 days, 11 days, 12 days. What kind of issue do you think that is going to, what kind of relationship do you think that is going to foster between you and the buyer? Definitely, if you have to explain that after the fact, as opposed to explaining that before the fact, that could put you in a less than powerful position. So that's just another reason. Now, for you listing agents, and just parenthetically, if the closing attorney is the holder of the earnest money and it is a cash transaction, it fails to close and the seller won't sign the release portion of the TNR, the closing attorney in the GAR contract does not have the option to interpret the contract and do the 10-day letter. The closing attorney must interplead it into a court, and now buyer and seller are involved in a lawsuit over the disbursement of the earnest money, and court costs and fees do come out of that earnest money. So just something to pay attention to when parties are binding under the GAR contract. They do choose to have the closing attorney as the holder of the earnest money, and it is a cash transaction. But let's go back to some other points about handling earnest money. Additionally, if it is a personal check or an ACH payment, a buyer can stop payment on those. So it's not as secure as, for example, certified funds or a wire. Additionally, if the buyer is sending the earnest money directly to the holder and you, the agent, are not actually taking the check, taking the funds to the holder of the earnest money, there can be additional delays. You need to make sure that when that buyer is sending those funds to the holder, if they're sending it, for example, by sticking a check in the mail by U.S. mail, you need to make sure that the buyer in their missive to the holder states what the property address is. Because if it is a check, a lot of times we get checks all the time, and it'll have payable to the company. It'll have the buyer's name in the corner with their current address. And in the memo section, guess what it'll say? Earnest money. The majority of brokers keep track of pending deals and transactions by the property address, not necessarily by the buyer's name. So if there's no reference to a real estate agent and no reference to the property address of the contract, we have no way of knowing where to attribute those funds. So they get deposited and put in a pile on hold, an orphan file, and we wait until an agent contacts us and say, hey, I don't see anything in my transaction management system. Did you get the funds for earnest money? Or your compliance broker will see the contract and see that the earnest money was due on such and such date and had the deposit date. We never got it because we got a check, but we don't know what property it goes with. So the holder sends notice to the parties that the buyer has defaulted by not sending in the earnest money. What kind of message does that send regarding the strength of the buyer to the seller? Not a great one. And the buyer says, hey, I sent in the earnest money. I sent in the earnest money. Then we have to track it down. We get the funds and we see, oh, yes, okay, now I see what the property was, but we had no way of attributing that. So if the buyer is sending the funds directly to the holder, whether it be a wire or by U.S. mail or even dropping it off with a staff person at an office, make sure, agents, that you let your buyers know to absolutely reference the property address of the transaction that the earnest money goes with, so it can be attributed, and the agent's name. That would be helpful too. Already told you about earnest money over $10,000. So again, under the GAR contracts and the RE forms contract, if the buyer were to default, the earnest money is liquidated damages to the seller. So you sellers, you listing agents, you have an interest, your sellers have an interest in the money too. Now, earnest money is not the consideration of a contract, so it is not required for a binding contract to be enforceable for real property in the state of Georgia. But everybody has an interest in those funds. So you agents on both sides of the deal, the buy side of the deal and the list side of the deal, both of your parties have an interest of those funds. It is your responsibility as the agent to follow up with the holder. Did you receive the earnest money? Did you deposit the earnest money? Did you receive the earnest money? Did you deposit the earnest money? You should be requesting proof of deposit of those funds from the holder, not just a picture of a check. I can take a picture of a check right now. That doesn't mean I sent it in, number one, even a certified check. And number two, that doesn't mean it was deposited. And number three, if it was deposited, that doesn't mean that the funds were good. So you definitely want proof of deposit. And then if the burden is on the holder, as outlined in your contracts, that if the funds are not honored by the bank, the holder must send out notice to both buyer and the seller that I don't have the money. In essence, your purchase and sale agreement is a receipt on behalf of the holder for the earnest money. If that money is not good, I never received it, or it was not honored by the bank, that means those funds are not on deposit in my account, and the holder should send notice to the parties saying, I don't have the earnest money. If I don't have the earnest money, there are procedures outlined in your contracts regarding how a buyer can cure the default. There is a time frame for the buyer to cure and make good on the earnest money before there are any seller termination rights. And the seller can choose to terminate after a certain time frame or go on with the contract. And again, all of that is outlined in the purchase and sale agreement. And again, also, if the buyer is sending the earnest money directly to the holder, agents, you need to make sure what address they're sending it to. Is it the proper address? Is it, there are a lot of brokers that have multi-offices. Which office did they send it to? What name was on the envelope? Again, staff at an office, if the buyer sent in a check for earnest money and they put your agent name on the envelope, the staff person received it in the mail, the staff person doesn't open up your mail. So they may have taken that check with that envelope, that mail with your name on it, and stuck it in your mailbox at the office. So you need to follow up again with the holder regarding, did they get the earnest money? If they did not get the earnest money, then the first thing to do would be go back to the buyer and find out how they sent it, where they sent it to, what name they put on the envelope, so forth and so on. Now, just a couple of other points. If you are dealing with a wire, regardless of the amount, based on all the wire fraud in the real estate industry, I know a lot of brokers and a lot of closing attorneys are not emailing wire instructions. And in the GAR purchase and sale agreement, it specifically says wire instructions will not be emailed to you. So how do you get wire instructions to a buyer? Well, point of practice for you as an agent is go pick up the wire instructions from your broker and from your closing attorneys so that you will have them in hand. And when you're meeting with a buyer, you can physically hand those wire instructions to your buyer. Just confirm with the holder that they haven't changed. That's number one. Number two, brokers and a lot of closing attorneys are sending the wire instructions via U.S. mail. Takes a little bit of time for you to contact your broker, give your broker the mailing address of the buyer, the broker to put the wire instructions in an envelope and send them to the buyer via U.S. mail. Additionally, there are a lot of closing attorneys who are no longer even using encrypted emails to email out wire instructions. You as the agent, do not be the messenger for wire instructions for your closing attorney. Let the closing attorney deal with your buyers for cash to close funds and for your sellers for handling payoffs. Again, but back to the topic at hand, earnest money. Another way would be let your broker know, or the staff person at your office, the phone number of your buyer, or you be with your buyer. Go to the bank, call the broker or the staff person, and the broker can tell the person, the buyer, the wire instructions over the phone. Again, it is the emails that are getting hacked and the e-faxes that are getting hacked. It's not the U.S. mail. It's not phone calls. It is the emails. But all of this being said, in your purchase and sale agreements, if the earnest money is going to be in the form of a wire, there is a place where the buyer and the seller negotiate for the time frame under which the buyer is to send those funds to the holder. Just note, if it's going to be a wire, both on the buyer side and the sell side, that it typically, you might need to put in a little bit longer time frame, not 2 days or 3 days, but something more like 5 days or 7 days if it's going to be a wire, just to account for the process for the holder or you, the agent, to get those wire instructions to the buyer for earnest money. So, a lot of information here, but hopefully these tips helped you out regarding the handling of earnest money. Number one, to make sure that it is handled in a way that is efficient, effective, in concert with what you are telling your buyers regarding what the contract says for earnest money, and to avoid any delays or any hard feelings. You need to make sure you understand all about earnest money and the handling of earnest money, how that is addressed in the contract to which you are helping your buyer and your seller, as well as the holder's policies. We get emails and questions in classes and emails and phone calls all the time regarding real estate issues, whether it be contract issues, license law issues, a combination there too. So please be sure to subscribe and so that you don't miss any of these video tips. And if you like this video, click on the one here, and I hope that one will help you out too. My name is Dana Sparks. I attempt to make even the most complicated of real estate issues crystal clear. Get it? See what I did there? Thank you guys so much for watching. Dana Sparks, broker of Maximum One Greater Atlanta Realtors, satisfying your needs with service, innovation, and education.